Hi, everyone, and thank you for joining us for this latest workshop, EPC Community Engage. This is our public-facing series, and we're going through some of the topics that are most important to our residents on the planning side of things, and we're also incorporating some other departments throughout the county. Today, we are going to focus on code enforcement, which can be kind of tricky, but we have experts here to explain to you exactly how to go through the process and also how to make it work for you and how to use it properly. So we are going to pass it off to some of our planning staff, and we also have one of our county attorneys here today. First, I'm going to hand it over to our Executive Director of Planning and Community Development, Craig Dossie, who's going to just give you a brief summary of what EPC Community Engage is and introduce today's presenters. So Craig, go ahead.
Thank you, Lauren. As Lauren said, we have this new program that we're referring to as EPC Community Engage, and it's really an effort by the county to try to provide our citizens and the general public with information about some of the county's processes and different programs that we offer. As Lauren also mentioned, we are with the Planning and Community Development Department. So today's topic, you're going to be seeing a lot of discussion about code enforcement, a lot of focus on things such as what we can enforce upon under our ordinances and our regulations, and also things that we cannot enforce upon, and setting expectations for what that process really entails and how long it can take at times. We will have other series that come out on Community Engage. Having said that, if there are folks out there listening to this, and there are things that you would like for us to touch upon in one of these events, we'd be happy to entertain those ideas. And at the end of this presentation, we will be providing an email address where you can send those topics for consideration. And we will look at those. And if they are something that we feel like needs to be addressed, or if we get enough requests about a certain topic, we will certainly try to tee up an event addressing that specific subject matter. So with that, today, Lauren, if we can advance to the next slide. As I mentioned, we're talking about code enforcement today. Really excited about the folks that are presenting for all of you today. A lot of knowledge, a lot of hard work goes into this process, and these are the folks that are responsible primarily for that hard work. First off, we have Mindy Madden, who was formerly our code enforcement supervisor. She was promoted to strategic services manager. Really all that means is she now supervises more than just code enforcement, but also served as a code enforcement officer for the county. Also presenting today, we have Mike Desmond. Mike is with the county attorney's office. He's an assistant county attorney, and they will be discussing kind of the process leading up to litigation. And then Mike obviously will take that handoff from Mindy and talk a little about the litigation process and what the county attorney's office role is in the enforcement process as a whole. I also want to introduce our code enforcement officers. You know, when we talk about El Paso County, you're talking about a very large area that needs to be covered in terms of code enforcement. And we have 3 code enforcement officers that do a great job covering such a large area. So you'll get familiar with these names, and certainly these are the folks that are out in the field and make that face-to-face contact with property owners. We have Joe Letke, we have Scott Shavak, and Charles Carlisle. They will be available to answer questions if need be in the future, if you have a question about a certain property. And they do have geographical areas, and I think Mindy can touch on that a little bit, that they work in specifically in the county. For today's purposes, you're going to primarily hear from Mindy and Mike. Next slide, Lauren. So I touched a little bit on this, but today's presentation, we're really going to focus on what the basics of code enforcement are, where some of the regulations come from, and the general process. We're going to be looking at that process and trying to give you the full breadth of what that entails from the initial complaint all the way to whatever the finish line is. It varies depending on the topic at hand. And then lastly, we want to provide some real life examples of where code enforcement was involved. We have some great photos of properties that we were called into action to enforce upon. So we'd like to provide those as well, just little bit of perspective of some of the things that we have to deal with. And with that, I'm going to turn it over to Mindy. Thank you all.
Thank you, Craig. Go to the next slide, please, Lauren. So just at a glance, like Craig said, we have 3 code enforcement officers for the entire unincorporated areas of El Paso County. So to kind of explain a little bit about which officer handles which area, Joe Letke handles mostly the north side of the county. So that includes Monument, Black Forest, up the pass. He also is over Cimarron Hills and Park Vista. Scott Shavak handles the southern part of the county, so that includes Fountain, Whitefield Security, Stratmore, Midway, Colorado Center, and Charles Carlisle handles the eastern part of the county. So they're pretty spread out. Code enforcement action is reactive, so we are complaint-based. Code enforcement officers do not patrol neighborhoods looking for violations. Again, we have 3 officers for the entire county, so we certainly do not have the manpower to be active in searching for violations. So just to give the viewers an idea of what caseload we're looking at for 3 officers, Scott, who again is the southern part of the county, he's sitting at about 200 cases for just him. So the southern part of the county is probably one of our busiest. Joe, the northern side of the county, is at about 100, and Charles, eastern part of the county, is just under 100. So they're pretty busy. Code enforcement officers also, well, I'll get to that in another slide, my apologies. So code enforcement utilizes a civil process rather than criminal. A lot of times we get residents calling us, asking us, when are you going to fine an individual? When are you going to issue a citation to my neighbor? Code enforcement officers do not have that ability. We do not assess fines, issue tickets. We utilize that civil process, which means we pass cases on to the county attorney's office, Mike Desmond, and we pursue civil action in court. So in other terms, we file a civil lawsuit against a property owner to gain compliance. Next slide, please, Lauren. So what do we enforce? So our county ordinances, I'll go through those first because there's really only 3 that we enforce on. That's requiring the removal of weeds and brush, prohibiting the accumulation of rubbish, and requiring the removal of unsafe buildings. Weeds and brush and rubbish are our most popular county ordinances. So if you're filing a complaint because your neighbor's not cutting their weeds, a couple things to keep in mind is the weeds have to be in excess of 9 inches in height, and the property has to exceed 2.5 acres in size. For the land development code violations, these are our most common complaints that we receive. Inoperable vehicles. And to keep in mind, unlicensed vehicles are not a violation. We hear that quite often. We also do not enforce on vehicles that are parked on the right-of-way on the street. Occupied vehicles, so someone living inside a vehicle or an RV on private property is another common land development code violation. Animal keeping, so don't think that you can't have your little furry friend. So with animal keeping, we do limit the number of cats and dogs to a total number of 4, unless the cats are kept solely indoors. Home occupations, our most common are landscaping companies, contractors, equipment yards operating from residential properties, setback requirements, and prohibited uses by zoning districts. And what that means, if you're zoned residential and you want to open up a racetrack on your property, that would be prohibited by zoning, by your zoning district. And development application approvals. So that is, for example, you received approval to operate that racetrack. And on that approval, you have certain conditions. You can't exceed so many customers per day, parking, whatever the case may be. Code enforcement would respond to that property if we got a complaint of a violation. Another application approval we look into is agricultural structure exemptions from the building code. So those applications are actually processed by code enforcement and inspected by code enforcement to ensure compliance. Next slide, thank you. So what do we not enforce? So there's a wide range of what we do not enforce, but these are the most common. So again, on-street parking, that is handled by the sheriff's office. Code enforcement does not enforce traffic violations or standards. If someone's living in a vehicle on the right of way, which is pretty common, again, that's the sheriff's office that would handle that. Code enforcement does not enforce the noise ordinance. That's, again, the sheriff's office. Building code, building permits, that's handled by the Pikes Peak Regional Building Department. Septic systems, that would be the health department. Code enforcement does not resolve or enforce civil matters or landlord-tenant issues. So a common one we get is the inside living conditions of a house is unsuitable. Code enforcement would not be able to assist with that. We don't enforce HOA covenants, cultivation of marijuana, or noxious weeds. Next slide, Lauren. Code enforcement process. So we have this wonderful program called EDARP, and EDARP allows residents to submit a complaint directly online. It allows citizens to upload pictures of their complaint. It allows citizens to submit that complaint anonymously. We do encourage citizens to use or to add their contact information on there. That allows code officers to follow up if there's any additional questions or if we need additional information in order to pursue enforcement action. But again, you can be anonymous. Any information that's submitted onto EDARP is subject to Colorado Open Records Act. EDARP also allows residents to go back into the system after they submitted the complaint and check the status. This allows residents to see the last inspection that was done, what the latest enforcement action was taken, as well as the contact information for the assigned code enforcement officer. In addition to EDARP, complaints may also be submitted by phone, email, fax, or again, directly online with EDARP. Next slide, Lauren. So code enforcement process, once we receive a complaint, again, that's all subject to Open Records Act. A case is opened and automatically assigned to a code enforcement officer based on the area the property is located. A lot of times we'll get complaints that the violation is occurring in the backyard. Code enforcement officers cannot just enter onto a property to check it out. We can't walk through their back fence, knock on the door and say, you got to show me. We can only inspect from public property such as the road, sidewalk, or from a neighboring property if that property owner gives us permission. This is why it's very important for residents to leave their contact information if they know a violation is not visible from the right of way. If the complaint was submitted anonymously and we cannot verify it, then we have to close that complaint out. We just have no other option at that point. Next slide, Lauren. Okay. If we're able to verify a violation and notice a violation is issued to the property owner and sometimes the tenant or renter, that notice provides 14 days to correct the violation or contact the code enforcement officer listed on the notice to request additional time. We encourage residents to contact code enforcement if you're unable to correct that violation within the 14 days. We do give extensions and sometimes continual extensions if progress continues to be made. But if we do not hear from the property owner, then we just move forward to the next step of the enforcement process, which is an executive determination. That executive determination is signed by Craig Dawsey, and that determination is what authorizes the county attorney's office to pursue litigation. Within that determination, the owner has 10 days to request an appeal. So what's very important about this is we get a lot of calls from residents saying, I'm working on it, I just need more time, I'm requesting an appeal. That's not what the appeal is. The appeal is you do not believe that the executive director issued that determination correctly. In other words, you're not in violation, so Craig Dossie should have not assigned that determination. If you want more time, then request more time. We're still happy to work with you. Our ultimate goal is to get that property into compliance, not take it to court. However, if we do receive an appeal within 10 days of that executive determination, then we schedule a hearing before the Board of County Commissioners, at which time we present evidence as to why Craig signed that determination. The property owner, whoever requested that appeal, would also have the opportunity to address the Board of County Commissioners as to why they believe that determination was issued in error. Okay. Next slide, Lauren. So I kind of already went over this, my apologies. So again, if that appeal is received within 10 days, we schedule a hearing before the Board of County Commissioners, and the board decides whether or not that executive determination was issued in error. So if they deny the appeal, then that determination is final and the case is sent to the county attorney's office. If they approve the appeal, then they're overturning the decision of the director to issue that executive determination. So again, if residents are looking for more time to comply, it's never too late to call code enforcement and say, I'm working on it, give me some more time. We're still happy to do that. That is our goal. It's also important to note if an appeal or request for appeal is received after the 10 days of the executive determination, it's untimely and it's not accepted, and the county attorney's office is authorized to proceed with litigation at that point. Okay, Lauren? So I'll turn it over to you now, Mike.
Excellent. Yeah. So like Mindy just said in the first part of the presentation, the focus here is really to make sure it never comes this far into the process, that it doesn't end in litigation, that the notice of violation gets responded to, or the executive determination, and through even the extensions of time, that you're able to work those issues out and bring the property into compliance with the ordinance and land development code provisions. And so if something reaches my office, we still have another step that we take prior to litigation. And it's a step that's not like required by statute or ordinance. It's a step that we just have implemented because we've seen a lot of results from it. And that step is to issue a warrant letter, or not a warrant letter, a warning letter. And it basically just informs you that the process has come all the way to this point. You've gone through the notice of violation, the ED, your appeal period is passed, or if you filed the appeal, you were unsuccessful in it. And now it is coming to the office of the county attorney, and we're going to be seeking to pursue litigation in order to bring the property into compliance. And that warning letter actually generates a decent response from property owners, and we're able to head off a bunch of cases that otherwise would go straight into the complaint process and litigation. We're able to actually communicate with the property owners at that point. I don't know if like seeing the attorney's kind of name and stuff on the letter starts to generate a little bit more of a response, but for whatever reason, it does start to motivate some people, and that's exactly what we want. We don't want to go into litigation on these matters. It's a last resort, and so we're happy to work with property owners in that context through the warning letter and to not even have to get to the complaint filing stage. However, several cases do come through and no one responds to the warning letter, and that ends up leading them into one of two real directions or buckets. And so basically, depending on the violation, if the violation is ordinance-based or land development code based, or sometimes both, and as you already saw from Mindy, there's different violation, like the violation will fall into one of those different kind of buckets where you'll have, like weeds or rubbish, and that's an ordinance. But if you have something that's like an inoperable vehicle, that's a land development code. Those two governing kind of laws or bodies of law basically say that you have to treat them in different ways. And so with an ordinance, we have a mechanism that we can use to bring the property into compliance called an administrative warrant process, where we apply to the court and the court grants us a warrant to go on the property and clean up. the property, but that's only related to ordinance violations. You're talking about weeds, you're talking about rubbish, those kinds of things. If it's a land development code violation, it kind of takes a different direction and has to go through a formal litigation process. And so I'm going to outline both of those for you. I'll start with the kind of land development code process for those violations. And then at the end, I'll talk a little bit about the administrative warrant application process. But to start off, it follows, if you have like a land development code violation and possibly some additional ordinance violations, those can be grouped together and brought in a formal case, and that would involve issuing a summons and a complaint that my office drafts, and essentially we file that with the court, and at that point we have the burden of serving you with those documents, and that's to bring you in, like to give you notice that the case is taking place and to allow you an opportunity to file an answer. And so we go through the county sheriff's office to execute that service process, and if that's unsuccessful, then we often hire a private courier to try to locate the individual. It can be difficult depending on the nature of the violation. Sometimes it's a piece of property that's only being dumped on but doesn't have a residence on it. And so it can drag out the process of locating the owner and being able to execute service. At the very kind of outer edge of service issues, we sometimes have to go back to the court and even ask for an alternative means of serving the individual through like publication or something, because we've made all of these different efforts to try to serve them and we cannot give them notice through these means that we've already utilized. And so that's a last resort. For the most part, we're able to serve individuals through the El Paso County Sheriff's Office and through a private courier. Once the property owner is served, they have 21 days if they're in state or 35 days out of state to file a response with the court. And this is a really important process, and we actually don't get enough responses from property owners. So when we file a complaint, what we're asking is for you to engage with us in a dialogue before a judge so we can have that third party, and to basically figure out the issues and figure out how we're going to bring the property into compliance with the ordinance or land development code. And so that conversation is only one way if you do not file an answer with the court. And so while we can't provide legal advice to you because we represent the county in this matter, when you receive that, you can reach out. When you receive like the service of process with the complaint, you can reach out to the court, and the court is very gracious with pro se litigants, which we'll get to in a minute. But basically that means somebody who's not represented by an attorney, and they tell you all of the timelines and what documents and where form documents are. So really take advantage of that. And if you receive a complaint, know that providing the court with an answer is in your best interest because it allows your voice to be heard. If you do not file an answer with the court, then after that 21 days or 35-day period, the county attorney's office is able to seek what's called a default judgment with the court. And all this basically means is that whatever we claimed in the complaint, the court looks at all that evidence that we provided before them and stuff and says, yep, we're going to grant you the default judgment, and we're going to give a court order that says this individual needs to bring the property into compliance with the El Paso County Ordinance or the Land Development Code. And that only takes place with a default judgment if, again, we do not receive an answer. If we receive an answer, then the court has two different voices coming into the court, and they're able to actually establish a date for a case to take place. It's usually, as you can see in the final bullet point on this slide, it's usually 6 to 8 months out because the court does get pretty backed up with the number of cases they're handling, especially coming out of COVID. And at this point, while we've handled a lot of cases telephonically or through WebEx, we've also been able to start to see some tread in being able to handle cases in person again, which is positive. Anyhow, back onto the matter at hand. If you go that route, we schedule a court date, and then you can either represent yourself or you can have an attorney represent your interests. And you pursue that route typically when you've already asked for extensions with Mindy, you've already tried to seek, compliance, and you believe that you're not being, like, your property's not being evaluated fairly. Like, for instance, you're not out of compliance for XYZ reasons. And so that's your opportunity to be heard, and that's the alternative to the default judgment. At the close of the trial, you'll receive a judgment from the court, but at least your voice is able to be heard in that manner of handling it. And then after that, we go to contempt of court proceedings. Contempt of court is when the court issues an order and they basically say to you, we've issued an order in the past, this order, the default judgment or the order post-trial, and you still are not complying with it on your property. And so now the El Paso County Attorney's Office will go to the court and say, they're still not complying. They should be held in contempt of court, meaning that you're basically just disobeying the court's order. And it's a legal mechanism for you to be able to, or for us to be able to clean up the property. After the default judgment or the court order post-trial, we don't have the ability to go on there and just enter and clean up the property and then charge you for the cost of that. That all comes after contempt of court proceedings. And at that point, we do a full new service on you, service of process, where we locate you and notify you of the contempt proceedings. Those proceedings don't take place without you. But when the court gets you in front of them, it's important for everyone to know that they absolutely, at this point, when it's usually several years into the process that Mindy laid out and that I've just laid out, it can be 2 years through all of this different process, depending on the backlog of cases that we have. The court is not usually very understanding of that much delay in cleaning up the property. And so when you get to the contempt of court proceedings, it's very important to take it seriously and very important to act on the property, because that's the last time you're going to have your voice heard before the court, before they issue a warrant that allows the code enforcement team to enter the property and bring the property into compliance. And then following that, they'd be able to place a lien against your property for the cost of that compliance, like efforts that they made to clean up your property. And so it's really important for everyone listening to, when it gets to, hopefully it doesn't, but a contempt of court stage, take it very seriously. That is the final step before you are going to have basically the court allow the county to come in and do the cleanup for you. Next slide, please. And so we discussed this a little bit, but the pro se individual is just a legal term for the individual coming without an attorney. And like I said, the courts and judges, they're just very, very understanding of that. They're flexible with scheduling. They like to break down the legalese or legal terms used in court to try to help you have a better understanding of what's happening. So don't be afraid of the process. If you get the complaint and think, oh, I don't know what I'd say in front of a judge, they're gracious. They really want you there. They want your voice heard. And they want to make sure that justice is effectuated in the county, and so that's their goal. And so don't be afraid of that. I've been on many of these different cases with pro se litigants, and the judges do an excellent job of making sure you don't miss anything or nothing goes over your head. So it's a really accessible way for you to have your voice heard again. A majority of our cases are dismissed due to voluntary compliance. So this is another key point that I think everybody needs to understand, is if it gets to the litigation stage, just because a complaint's been filed does not mean that you have to go to trial. A lot of people don't understand that part of this process. Complaint's been filed. That is a great wake-up call to say, hey, I need to reach out to Mindy right away. I need to clean this thing up this weekend or next week, and I need to get and tell them and show them pictures, say, hey, this is done, and then they swing by and they take some photos and say, and the code enforcement says it's all done. My office loves filing motion to dismiss. It just dismisses the case, and we don't have to go through the process. We do not have to go through the trial or a default judgment or contempt or any of the other things I got into, because you brought the property into compliance. That is next to someone responding to like the notice of violation and just cleaning it up. That's the best. It's just being able to dismiss the case and say it's in compliance. There's no need to move further. So that is what we seek in these, and a majority of the cases we do get to dismiss. However, as we just discussed, if they do have to go through the entire process, it can lead all the way to even facing civil penalties in that contempt level. And what I mean by that is the judge can issue fines and say, I'm going to give the violator 30 days, the property owner will have 30 days to comply, and every single day that they don't comply, I'm going to issue a $50 fine. And if in 30 days they come back and show that the property is in compliance, then there'll be no total fine. But if they don't, then there's going to be a $1,500 fine that accumulates over those 30 days on top of the cost of the county having to clean it up. So it can get pricey in that contempt hearing process. And the intent of the court is to force people to take action on bringing their property into compliance. It is a last measure. That's why it's at the very end of the process, but it is there, and it's important to acknowledge that it exists and to take it seriously if the case ever gets that far. And then if involuntary compliance is not achieved, I'm reading this last bullet point. Yeah, we already discussed that with the hearing for the judge. Next slide, please. And so right before this slide, actually, yeah, there we go. So this is the other process, the other prong of like the bucket that these cases often fall into. And so this would be if you have an ordinance violation. An ordinance violation, like we discussed, the rubbish and the weeds, those violations can be addressed without having to file a complaint. The ordinance allows for the county attorney's office to file what's called an administrative entry and seizure warrant application with the court. And essentially what that is a mini, I view it as like a mini trial because I have to submit an affidavit from code enforcement, and all an affidavit is just a sworn statement that is coming from an individual, just as if they were testifying in court. They're saying, this is my official statement on the matter. So we attach an affidavit to this application that says code enforcement observed these violations. We attach photos and evidence to those particular applications. And we attach an argument saying that the ordinance allows us to basically just petition the court to put this request before the court to be able to clean up the property without having to go through a full trial with complaints and contempt proceedings and all of that. And the ordinance permits this action for us to take this action. And so that's important for everyone to realize, that if they just have ordinance violations and you're talking about something like a rubbish accumulation, we can file this application with the court, and within usually 21 days or less, we receive an answer from the court, and that answer includes a warrant. And it immediately allows the county to exercise that warrant and be able to go on the property and clean it up and bring it into compliance with the ordinance and code, or not with the code, just ordinance. And so that is a mechanism available to us. Again, in this process, we try to reach out to the property owners repeatedly before we get to this point, to let them know that this is the stage that we're at, along with the warning letters to let them know that where we're at. And then once we get to this point, we also seek service on them of the application so they know where we're heading with this. And then when the court grants the warrant, though, that's when it's time for the county to take action and to clean up this property. I've said this a few times, but this is usually far along in the process. So it's not like this happens, within, a couple weeks and you're like, oh, they just called me about this last week. I was on vacation and now they're on my property. That's not the case. These typically take quite some time. They can take even out to 6 months and longer sometimes, depending on the availability of personnel to execute the warrant, budgetary constraints, and other issues that we might have on our end with being able to bring the property into compliance. And during that time, our number one goal is for the property owner to bring it into compliance on their own. Because if we have to do it, as the final kind of section of this slide says, the costs are billed to the property owner, and we basically go before the court. We show them our receipts for everything that we had to do or everything we had to contract to have done, and then the court takes that and says, all right, we're going to enter judgment against the defendant, who's the property owner in this case, and then that gets recorded, and that's a lien against your property. So if you ever go to sell your property, that goes along with it, and that has to be paid before that sale can take place. And so we definitely do not want to reach that point. We would like people to respond to the NOVs and the EDs and be done with the process at that point. But if it does go farther, especially in the ordinance section, remember we had land development code and ordinance as two different buckets. We can execute a warrant pretty quickly through the courts because we don't have to go through the complaint and the other stuff that's needed to remove a vehicle, let's just say, like an inoperable vehicle. We couldn't use this mechanism to remove an inoperable vehicle, but we could do it to clean up weeds and to remove rubbish from a property. And so that about sums up the litigation side of it. One quick caveat to it. If we're dealing, and this isn't quite part of the code enforcement thing, but if we are dealing with like burned out buildings or demos and stuff, that's an entirely separate process. That involves Pikes Peak Regional Building Department, and that involves a lot of state regulations. And I just say that because a lot of times people see these properties and they see a dilapidated property or a burned out building and they wonder what's happening from code enforcement side. That's usually being handled by the Pikes Peak Regional Building Department, and they've got state requirements and regulations that they have to comply with that are far beyond a typical like court case or even this typical abatement process. Those processes can take months just to reach all the levels of permitting that are needed to be able to go on someone's property and tear down a burned out building. So I just think that if anyone's thinking that's code enforcement, that's not, that's regional building, and their processes are different and even more involved. And that's all I have. So I think back to Mindy with the next slide for some examples.
So before I get into the pictures, I just wanted to point out kind of the common theme that me and Mike keep putting out there is work with code enforcement, contact code enforcement, we'll work with you. But what if you're the person submitting the complaint? You're hearing, oh God, they're just going to keep giving them time after time after time, and it could take 2 years. And the process is not as fast as we'd like it to be, especially when you're dealing with court dockets who, you know, these judges will have a murder trial and then go into a case regarding junked vehicles. So it's the same judges that hear those cases. So if you submit a complaint and you're concerned about the time it's taken and why are you still working with them, contact me, contact one of my code enforcement officers, and we'll explain to you where it is in the process. When it gets to Mike, you know, Mike and his team work great with code enforcement, you know, the code enforcement team will go through the 90 cases we're dealing with and say, you know what, Mike, this one's really bad. Let's push this one up and get this in court sooner. Or, you know what, Mike, this one's been out there for quite some time. Let's do this one first. So for complainants, if something changes, the property is worsening, call us. Don't just assume that nothing's being done because it's on our radar. It's on Mike's radar. So we do work with people, but if they're not showing those results, we do move it forward. And unfortunately, there's, you know, quite a number of cases that are waiting to be filed. COVID really set us back in regards to filing with the court. But again, call, don't just get mad and assume nothing's being done. Give me a call. I'm happy to talk to you and let you know where we're at. All right, let's see some pictures. Lauren. So this property is down in the Stratmore area, and it actually borders a county park. So people would go for a nice little stroll with their kids and see this. And it was actually a burned out structure that was just not getting cleaned up. And we removed 15 truckloads to get this property back into compliance. Lauren? This property was out east. These residents weren't able to pay for trash service for a number of years. And so code enforcement did a cleanup on it. We removed 12 truckloads of rubbish. To give you an idea how big this pile was, we were pulling out treadmills and bunk beds and couches out of this pile. And at the end of it, the residents were actually thanking us for stepping in and helping them, which we don't run into that very often. But this was a good one to get cleaned up. Next one. This property up in the Black Forest area, this was a big one. It was on the news, actually came out on it. This one was a massive one. Removed 58 truckloads of rubbish, in addition to 44 dumpsters, 40-yard dumpsters, as well as about 90 gallons of raw sewage. So when people get upset about why can I have someone live in an RV on my property, this is one of the reasons why. You know, we were just finding buckets and buckets of sewage, and neighbors don't want that next door. So again, this is one of the reasons why those regulations are in place. If you go to the next slide, Lauren, these are the after pictures. Unfortunately, we are still dealing with this property. It's regressed, not to the same extent, but it's kind of regressing back to its previous state, minus all the wood. So Mike's team is working with code enforcement on getting this one before a judge. Next slide. This property is also down in the security, well, this one's down the security Widefield area. This was about 4 truckloads, which doesn't seem like a lot until you think of the size of lots that's down in security. We also removed about 100 tires from this property. This property has since been sold and bought and flipped, and the neighbors are pretty ecstatic about that. Next slide. This property is out east. We removed about 23 truckloads of debris from this property. You know, I definitely can't show all the, you know, couple hundred pictures that are taken at each cleanup. So if you can see in the bottom left-hand corner, you see that there's still some stuff there. Well, when code enforcement does a cleanup and it's contractor, we don't take every single piece of their belongings. We take specific items that meet the criteria of our rubbish ordinance. So ladders, tools, you know, that sort of stuff we do leave. So people kind of, you know, freak out a bit when they think code enforcement's doing a cleanup, that they're just going to be left with absolutely nothing. That's not the case. We have a goal in mind to get this property in compliance and just remove what is the violation from the property. Next slide. This property is down south, Colorado Center area. Only a couple truckloads, but again, these are smaller lots. Neighbors are very close. You couldn't walk down the sidewalk in front of this property, barely even see the front door. So we were able to get that looking pretty nice. Next slide. This property is in the Stratmore area, pretty close to that first property. Again, this is a mobile home section of Stratmore, so these are small lots, and we've removed 17 truckloads of rubbish from this small property. Next slide. This property is out in the eastern part of the county. A huge trash pit. That pit was probably 3 to 4 feet deep, and we removed about 33 truckloads of rubbish from this property, which was more than just what I'm able to show in this picture. From this particular property, we removed almost 1,000 tires, and we still were not able to get them all. But, you know, pretty big cleanups, some small ones. Again, we're looking at the impact the property has on the neighbors, on the neighborhood, in order to go in there and do the cleanup. We do have a select number of funds every year to do these cleanups, and once we exhaust those funds from the year, we start building the list of abatements for the following year. So I think last year we were able to get about 10 out. This year we've already done we've done 2 so far, and we got a couple lined up in the queue. So anyone listening that, you know, hopefully abatement never occurs on your property, hopefully your property is all nice and neat. But again, we're there to get the property in compliance. We're not there to judge you or just take everything from your belongings. We do work closely with the sheriff's office on these cleanups, because not many people are very happy to see us when we show up. But again, we're not there to judge, put you down, or just heavy hand you. We're just doing what we need to do to get that property in compliance. And so that is our goal. So that's, I believe that was the last one, Lauren.
Yes, it was. Sorry, I was unmuting myself there. Thank you, Mindy and Mike. As hopefully everyone can see, when I first started interacting with code enforcement, it was amazing to me the amount of work that they do. So hopefully some of these images you guys can see, they work really hard, and Mindy is probably one of the most patient people I've ever interacted with at the county. She does a great job, not only with the people who are complaining because she knows this is important to you, but also to the folks who are non-compliant. So when she says reach out, she definitely means it. And that will take us to this links and resources page that we've put together for you guys. We're also going to post this on our planning and community development website. So if you guys have someone you know who may want to watch this presentation after the fact, we do have a recording of this, and it will be posted on the website for the foreseeable future, so you can go back and watch this and also find these links. So the first thing you'll find is just the code enforcement website. I know it's kind of long, but it's basically, if you go to the El Paso County main website, which is elpasoco.com, you can navigate to the different departments and just go ahead and click on planning and development, and you'll find a link for code enforcement, but the direct URL is there. EDARP, which is the website that Mindy was talking about where you submit your code enforcement complaints, is just epcdevplanreview.com. So that's that second link there. You can do a whole bunch of things on EDARP, but one of the tasks you can complete on there is submitting a code enforcement complaint. And then if you have any general questions about this, you want to follow up, a good way to get in touch with our planning department in general is this email here at the bottom. That's plnweb@elpasoco.com. That's a general inbox for our planning department, and they can help you route your questions to the right departments, the right representatives in our planning department. I just want to say thank you again to Mindy and Mike for taking the time to present today. Thank you all for joining us, and to our code enforcement officers who support Mindy and work really hard to, work with our residents. It's a small department, but man, they get a lot done. And we appreciate them and appreciate their patience and willingness to work with all the residents in our community. So hopefully you guys learned something about code enforcement and this process and how to work with it and make it work for you and utilize it correctly. And again, visit the planning department website. And you can find out even more about code enforcement. And we will be posting this presentation on our EPC Community Engage page, which is also on the Planning and Development website at the main elpasoco.com. That's all we have today. Thank you guys so much for joining us. Thank you to our presenters, and we will have another EPC Community Engage on a different topic coming up in a few months. I believe September will be our next one. So we will see you all then. Thank you.